The first thing I would think about is what is a dupe to start off, right? So a dupe is an affordable alternative to a high-end product. But the key thing is that the consumer knows that it's not the original product. An interesting consideration for brands in the US is, what do you do in that situation? Because under the Lanham Act, which is the law that governs trademarks or brand protection really, the key thing is that the consumer is confused. So in a situation where it's a dupe and the consumer knows that it's not the real thing, it's just the affordable alternative, how do you navigate that? And so there's some cases that are progressing that will hopefully give guardrails around what that looks like. And an interesting thing to note too, pointing out that Reed Smith is a global firm, colleagues in the UK have seen the Iconics case, which came out of the Supreme Court. And that basically says that confusion doesn't have to be at the point of sale. So if the person who buys it knows it's a dupe, further down the chain, I'm purchasing it, I don't know it's a dupe, that can rise to liability. So that's an interesting way to think about how there are different considerations in different jurisdictions. The US is evolving, but somewhere like the UK kind of has some guardrails around how you can navigate dupe culture as a brand.